I'm going to time myself so I don't go over everybody else's time, because I'm used to being the last speaker of the night, and I asked to be the first speaker this year so that everybody wasn't asleep by the time they heard me. So I figure we leave that to Jim now. So you still might fall asleep, but you know. So as Rich said, I've been nominated to talk about conservatorships tonight. And I'm going to start by talking about what a conservatorship is and what a conservator is. A lot of times people say, what exactly does a conservator do and what's their role? So a conservatorship is a proceeding in the probate court where the court appoints a person, so a conservator, to make healthcare decisions for you and to handle your financial affairs for you. And the conservator of the person is the individual who is going to make healthcare decisions for you. And the conservator of the estate is going to be handling your financial affairs for you. We have two different types of conservatorships. First, we have a voluntary conservatorship. And a voluntary conservatorship is where you're making a petition to the court and asking the court to appoint somebody to be your conservator. Okay? So it could be you're looking for a conservator of the person to help with your health care decisions. You're looking for a conservator of the estate for financial decisions. But you're making that petition. And you're asking the court to designate or to appoint somebody that you choose. And I'll talk a little bit about why, a little bit later, why you would want to file a voluntary conservatorship. There's no incapacity determination in a voluntary conservatorship. So there's no medical records that are required in connection with a voluntary conservatorship proceeding. And you maintain your capacity. Voluntary conservatorships can be terminated with 30 days notice to the court. Involuntary conservatorships, as you might expect, is something that you're not looking for. It's somebody else, a third party, that's petitioning the court and asking for somebody to be appointed as your conservator. And again, it could be they're looking for a conservator of the person, a conservator of the estate. It could be one or the other. It could be both. The judge chooses, or the court chooses, who that conservator is going to be. However, while you have capacity, so while you're doing your estate planning documents, you can do a designation of conservator in advance so that if the time comes where you need a conservator, then you're saying, I would like such and such a person to be my conservator. Now that being said, it's not an automatic thing. Just because you signed this designation of conservator document earlier in your life, it's not automatic that the court's going to appoint who you've named. They're going to look at the facts and circumstances at the time. Because let's say, for example, I do a designation of conservator now, okay? And I name my daughter as a person that I want to be my conservator if the need ever arises for me to have a conservator. But let's say 20 years from now, I haven't changed my documents, and maybe my daughter's not the best person under the current circumstances. So the judge is going to look at all the facts and circumstances at the time. There is a determination of incapacity in connection with an involuntary conservatorship. So in order for the judge to appoint a conservator for you, in the involuntary conservatorship, we need medical documentation. So your doctor is going to examine you within 45 days of the hearing on the conservatorship. And if we can't get that medical documentation to show that you're incapacitated, then the judge could introduce some other types of evidence. But in most cases, we're going to need the physician's report showing that you're incapacitated in order for the judge to appoint an involuntary conservator. An involuntary conservatorship is difficult to terminate. It's not impossible, but it's difficult to terminate. Because in order for you to have a termination of an involuntary conservatorship, you would need to be restored to capacity. So most times when we're dealing with most common situations where we have involuntary conservatorships is when somebody has a memory impairment, an Alzheimer's, dementia, something like that. So most times they're not returning to capacity. But there definitely are situations when termination is possible. So we have some similarities between an involuntary conservatorship and a voluntary conservatorship. There's cost involved, okay? So there's filing fees for the conservatorships, and throughout the conservatorship, as long as it's in effect, there's accounting requirements to the court. So there's fees associated with those accountings. For the conservatorship of the person, there's an annual conservator's report that needs to be filed by the conservator that just updates the court as to your current medical condition. Have there been any changes, improvements, decline, how often you visit with the conserved person, things like that. And then on the financial side, there's periodic accountings that are required to be filed with the probate court. There's ongoing probate court supervision, which is a good thing because sometimes that's what we're looking for. We want somebody looking over a conservator's shoulder or maybe a family member's shoulder, so we bring it into the probate court with the conservatorship. But conservatorship, the proceedings, it's not automatic. So for whatever reason, if we need to have a conservator appointed, it's not going to just happen the next day. Notice has to go out to interested parties. There's going to be a hearing. With the involuntary, we're going to need to get the medical documentation. So there's some delay. It's not an automatic process. So I'm going to give you some examples of maybe some things that we might not think of when, how would we end up with a conservatorship when we least expect it, okay? So I'm going to talk about the perfect family, and as you can see, perfect is in quotes because in reality, is there a perfect family these days? What is a perfect family? Okay, so we have a couple. They went to our Chipman Mazzucco seminar a few years back. They heard my partner, Rich, talk about the importance of incapacity documents, signing a healthcare proxy to name somebody to speak for them and make healthcare decisions if they're unable to make them for themselves, and the importance of having a power of attorney in place so that there's somebody in place to make financial decisions and handle your financial affairs. The couple meets with Rich after the seminar. They put people in place. They name each other as their healthcare representative. They name each other as their agent under their power of attorney. And in addition, they name successors. So maybe they name adult children or other family members as successors in case they can't act for each other. This is great, perfect, hip hip hooray. They've done everything they're supposed to do after going to the Chipman Mazzucco seminar. They've listened to Rich. What could possibly go wrong, right? Our documents are in place. We could put them away and forget about them. Well, unfortunately, that's not what happens a lot of times. And instead, what happens is the boxing gloves come out. We always end up, well, not always, we end up with conflict in a lot of situations, despite our best efforts to get all our ducks in a row. So, what if we have a divorce, okay? You've named your spouse as your healthcare representative. You've named your spouse as your agent under your power of attorney. And then years later, you get divorced. Well, divorce is going to terminate the authority of your agent, your ex-spouse as your agent or your healthcare representative. So that's a good thing because probably most people who are divorced don't necessarily want their ex-spouse to be named as their healthcare representative or their agent. But what happens if we haven't named a successor? So now all of a sudden we don't have somebody in place in case we're incapacitated. And while the first time around, Chipman Mazzucco seminar, met with Rich, great, we were proactive, got our documents in order. But how about now, after the divorce? Maybe we're not thinking about setting up new documents or naming new people. So we might be in a situation where we don't have anybody in place to make healthcare decisions or handle our financial affairs if the need arises down the line. Or how about remarriage? And then we add stepchildren into the mix. I'm sure none of us can envision any problems that we could run into with, remarriage and stepchildren. How about, let's just say my parents got divorced and my father named me as his agent. Let's say he named me as his healthcare representative, and he named his new wife as his agent under his power of attorney. So I'm in charge of healthcare decisions. His wife is in charge of the finances. Simple, right? I mean, we're always going to agree, of course. But then down the line, my father, he needs some type of medical care, and he's unable to make the decisions for himself. I decide that I think it's best, based on my dad's wishes that he's told me over the years, I think it's best for him if he's in maybe an assisted living facility, okay? Well, I go to my stepmother, I say, listen, I think this is best that he's in assisted living, he's gonna get better care there, maybe it's in a memory impaired portion of the facility, great. My stepmother says, I'm not gonna pay for that, and she's in control of the money. Well, once again, we have a conflict. So what do? Well, in that case, just like in the divorce situation where you don't have somebody named, we might end up in the probate court looking for a conservator to be appointed. And maybe I'm the one that's filing the petition for the conservatorship. Maybe I'm looking to be appointed as conservator. Maybe it's my stepmother that's filing the petition with the court, looking to be appointed as stepmother, or appointed as conservator, okay? And this is when I'm talking about the judge is going to look at all the facts and circumstances at the time and decide whether I'm the better person to be a conservator. Should I just be conservator this day or in person? Should I be both? Is my stepmother the better person to do act in these roles? Or neither of us? Maybe an independent third party. Maybe not a family member. There's attorneys that sometimes serve as conservators. There's individuals that serve as conservators. That's their full-time job. So again, we end up in the probate court because we're trying to resolve a conflict despite our best efforts. With the divorce, the first time around, before the divorce, we had documents in place. Remarriage, my father had his documents all in place. He thought he was all set, but ended up in conflict. Or how about in just a situation where a married couple, children together, and on your documents, you've named your two children. Let's say I named my daughter and my son to act jointly with respect to either my finances or my healthcare decisions. And what if they disagree? Then what? There was just an episode of Grey's Anatomy last week, and there was three sisters. The sister was on life support, and the other two sisters hadn't seen each other in years. And they're in the hospital room, and they're arguing over what's best for their sister, take her off life support, don't take, they disagreed, fighting. And, in that situation, the doctor said, listen, you have to do what's best for your sister, okay? And that's what it comes down to. We can't just look at, let's jump into the probate court with a conservatorship to resolve any conflict. That's not what it's all about. If it's a simple disagreement, a difference of opinion, the hope is that you're going to come to some resolution. And you have to keep in mind that you're not, as a healthcare representative, as agent under a power of attorney, and even as a conservator, you're not speaking for what you want. You're speaking for what that person would want. So having a discussion with your parent or whoever is naming you, okay, if you're naming your kids or even your spouse, it's important to have discussions about what your wishes are. Okay. The appointment of a conservator can only be done if it's in an involuntary situation, if it's the least restrictive means of intervention. So if there's something else that's working for you, for example, you have healthcare proxy and you have a power of attorney that's working for you, then there's no need for a conservatorship, and the judge is not going to appoint a conservator in that situation. What are some other reasons we end up with a conservatorship? I talked earlier about voluntary conservatorship, and maybe you thought, what's the point? Why wouldn't I just do a power of attorney, name who I want to name to act for me, and then I avoid the cost of the probate court, the conservatorship, I avoid the restrictions. Why wouldn't I just do that? Well, what if you need to be protected from yourself? What do I mean by that? Let's say my daughter lives with me and my son doesn't. And my daughter's always asking me for money, like a kid would ask for money. I know, that's kind of a silly concept, but so my daughter's always asking me for money, and because she's living with me, I feel bad because she does a lot for me, so I'm always giving her money, okay? And then my son is in my other ear saying, what are you doing? You need to save your money. Just what if you need it for your care? You should be saving your money. So in that case, I could go to the probate court and file for a voluntary conservatorship, maybe I'm going to ask for my son to be appointed as my conservator, so that at least if my daughter is coming and asking me for money, I could say, sorry, you have to ask your brother, he's my conservator. So it kind of puts that, if I'm afraid of retaliation, if I say no, then at least this is a way I could kind of put the focus on somebody else. Might not help the conflict between siblings, but at least it takes it off of me. Or what if I want to stay home and I'm afraid that somebody's going to try to put me into a facility? Now, your healthcare representative and even your conservator of your person can't put you into a facility against your will. A conservator of the person needs to get permission from the court to change your residence. So if you want to stay home and you really think that you're going to fall under the pressure, family members, oh, you need to go into a facility, you need to, then voluntary conservatorship, at least conservator of the person, may be the answer, because then your residence can't be changed without permission from the court. So again, it's a protection for you. So, for example, if you're afraid to say no, then you have that protection. Sometimes it's adult protective services that gets involved, or a social worker at the hospital who suspects neglect or something like that, or financial exploitation. So maybe they're the ones that are filing for the conservatorship in the probate court, and they're not asking to be appointed as conservator, but they're asking the court to appoint somebody to act for you as your conservator. Or again, maybe you just have all these outside influences from, you have charitable organizations calling you scams, caregivers, neighbors, family members, handymen, door-to-door salesmen, whatever it is, maybe you're just cracking under the pressure from so many outside sources. So, what are some things you can do to try to avoid a conservatorship? Well, write down your wishes, okay? having a conversation with the people that you've named as healthcare representative, agent under a power of attorney is great, but maybe putting those in writing just so they know, do you prefer to be cared for in the home to the extent possible? Or, even if it means using your last penny, or going into a nursing home. Would you rather be in a nursing home? I know a lot of people, that's their last choice, but maybe you'd rather go to assisted living. So write down your wishes. And then also periodically review your documents to make sure that the people that you've named as your healthcare representative or your agent under your power of attorney are still the people that you would want to have in place. Maybe there's been a death of one of the people you've designated, or their own illness. So review those documents periodically. Anticipate conflict. Don't always assume that everybody's going to get along. Everyone says, my kids get along great, it's perfect, and everyone gets along, no problems. But in reality, like I said earlier, the boxing gloves always seem to come out, especially when there's a death in the family or there's an incapacity. So when the parent's no longer involved and doesn't have the capacity, that's when it seems to be the case where the kids start arguing. So anticipate the conflict, and when you're naming people in different roles, if you're naming them jointly, really think about what potential problems there might arise down the line. And then I think probably most important, and something people don't think of or realize, I think, if you're named as a conservator, or if you're going to be designated as a conservator, know what role you're taking on before you take on that responsibility. It's a big job. On the financial side, there's the accounting requirements. On the healthcare side, sometimes it's coordinating caregivers, things like that. Probate Court Administration, they recently set up a self-study online training course for conservators, which is fantastic because, again, it's a big job, and I don't think people realize how much they're taking on. So it's a great tool to take advantage of. And then also there's a Conservator's Standards of Practice that's published by the Probate Court Administration, and it gives guidance to conservators of what their roles and responsibilities are. So kind of going through all those different steps, I think would be very helpful for anybody that's serving as a conservator. So that ends my presentation for tonight. Thank you all for your attention. And it's now my pleasure to introduce my partner, Dick Emerson. And Dick is a former Reading probate judge. I understand way back when he was an Eagle Scout and also a retired U.S. Army lieutenant. He practices primarily in the areas of estate planning and probate, and has had an extensive legal career. And interestingly enough, it spans over my entire life. I understand that on the basketball court, his nickname was the Blade because of his sharp elbows. And while we don't see him dribbling a basketball through the hallways of Chipman Mazzucco, he is known for always wearing a suit. And we often wonder whether he wears a suit when he's mowing the lawn. So Dick's kind heart and generous spirit translate well across his practice areas. While Dick sometimes insists that we all rise to bring him back to his probate court judge days, I think we could all stay seated as Dick comes to the front of the room. So thank you.